Just like the street lights lit this town, like a fire in a blaze, gotta burn it down. Can't be afraid to leave this out. We got this far, don't know how. I see danger in your eyes. They know we'll burn down the night. Coming just like the sunrise. You know that we're gonna let it away. Tonight, we're gonna let it away. Tonight, we're gonna let it away. Just like the sunrise, we're gonna let it away. Just like a spark that's breaking out. Can't make a stop, can't turn back now. We know that there's no room for doubt. No, we can't turn back now. I see danger in your eyes. They know we'll burn down the night. Coming just like the sunrise. You know that we're gonna let it away. Tonight, we're gonna let it away. Tonight, we're gonna let it away. Just like the sunrise, we're gonna let it away.
Hello, welcome in everybody. Sorry my lighting is off a little today, but I can't get this light to turn on. I don't know what's going on with it. It'll turn on for like a second, like that, and then it just goes away. It's probably a setting. I know it's a setting because it's a brand new light, but we'll get it figured out by tonight's live. But it looks really dark behind me even, so maybe I'll turn on my light, maybe back behind me. But welcome in everybody. Welcome to today's live. We are doing an afternoon live today. So we're just like all over the place with our lives the last few days. But Bryan Kohberger is going into court. And if I sound like I'm out of breath, it's because I am. I was running around before the live. I had to grab a drink and stuff. I was like, oh my gosh, I forgot to grab a drink. So let me go ahead and welcome you guys in, and welcome to anybody that's new that comes in. If you watch on a replay, make sure you hashtag replay in the comments below, or just leave me a comment. That way I know that you watched, and let me know if you enjoyed it or not, or what you think of the proceedings. So I have too many apps on my phone. Just go to the end. I don't know if we'll do a late live tonight or not. I'm debating on that, baby girl. Probably just today. Maybe we'll do both. But welcome in, everybody. Hey, Princess, how you doing? Hey, Willows. Hey, baby girl. Hey, Ladybug. Hey, Debbie. Hey, Catherine. See, Catherine, we needed you here the other night. You were in here when we were reviewing Bryan Kohberger's supposed friend that came forward. Because are you from New Jersey or Pennsylvania? I know it's one or the other, but you would be like, that is a Pennsylvania home if I've ever seen one. Hey, Cal, welcome in. Hey. I'll say, hey, Catherine again. But hey, Catherine, I watch every BK court hearing with Tanya. Oh, I'm so glad. I'm glad you guys come in here, because there's everybody and their brother is live today about this court proceeding. And if I look a little shiny, it's because I did skincare. If you want to know about the products I use, I put them in the description now. I just looked at myself and I was like, oh, I'm shiny. So yeah, that's what I hear, that Karen Reed verdict is getting ready to come in. So we'll have to see. I'll keep my eye out. That way I can let you guys know if anything happens. But yeah, I know, Dave. I was gonna say it's been a while. I feel like it's kind of hard when you're like into a case. Like, do you know what I mean? Like when you're really like you're into this, like Karen Reed. Like if you're into Karen Reed, most people are really hardcore into it. You know what I mean? And they want to watch the whole trial. And I understand that, especially because we're going to have a trial for Bryan Kohberger here in August. So I'm sure everybody will be just as excited to see that go towards a trial and a resolution as well. So hopefully they find a resolution today for Karen Reed's case. Hey, Wandering Orphan. Hey, Ashley. Welcome in, everybody. So I was actually listening into this new News Nation did like a new video over the Idaho 4. It was over the DoorDasher, and Banfield went over it last night, and it got me thinking. And I'm going to tell you what I was thinking while we're waiting on court proceedings to come up. Let's see where we need to go. Let me go ahead and pull those up. Actually, I think I can go right here. And let me know if you guys think that if he will actually get a continuance today. I'd like to know. Well, let me see what I have up here. Actually, okay. So I was going. I'm going through like this whole down roll. Like I'm going in a spiral with this case. I feel like every day like I hear something different, and I'm like, wait a minute. So remember the DoorDash lady came. Well, she didn't come out. She kind of was forced out. But her video of the traffic stop, and then the body cam footage of her and her saying that she was the DoorDash driver. She it didn't register until Ashley Banfield actually said it. And then I was like, wait, hold on a second here. So she's saying, right, that, and I believe her. I'm not saying I don't. Hey, Tom, and welcome in everybody else. Hey, ALR. I didn't even go through the rest of you. Hey, Amy, welcome in everybody. Hey, Warflare. Hey, Margot. Hey, Gwen. Hey, Nicole. Hey, Levitating Elephant. I didn't want to miss this because I was like, this was fresh in my brain. But so she's been covering Diddy. Oh my gosh. Like if you wanted some Diddy coverage, Nancy Grace has been doing Diddy like once or twice a day. She is on Diddy like she was on the Murdoch case, like a dog with a bone. She is on it. Hey, Kathy, and welcome in, everybody. If I missed you, if you guys actually don't mind, take a second, hit the like button for me. I promise you'll like the stream. I'll give you a promise. And that way we can, maybe get into the algorithm today. There are so many people that are streaming. It would be nice to get some people to come in. But Ashley Banfield, she repeated it. So I had like 3 people repeat this to me, and then it finally stuck. So the woman in the video, MM, says she's got to go to trial, or she's got to go, to be a witness on trial for the girls' and Ethan's death. And she says, I saw Bryan Kohberger. I parked right next to him. So if you're a DoorDash driver, right? Like she would have had to have parked next to him in the parking lot, in the front, in the driveway. Right? She says she parked right next to him. So in my mind, that makes me think he pulled in the front driveway. Because if you go to like maps or whatever, and you look up, let me see if I can, where did I put it? Let me just go to this first so I can just go like this way. This is so much easier. Let's see if okay. So if you look on directions, and I just went from Bryan Kohberger's apartment to the King Road residence, it takes you right into their driveway. So that's what the DoorDash app's going to recognize. It's not going to take her all the way in that back parking lot behind the house. And then, she's not going to walk down with the food, or, you know what I mean? Whatever it does, it's not going to do that. It's going to take you Queen Road right to, this is where the house used to be. And then that was the driveway. So do you think that he parked in the driveway? Like try to blend in with the cars? Because if you remember, there was like 4 cars in a row and then another car here. So he could have pulled right into that little, like right behind the first car. And then I have to pull up the picture to see whose vehicles are right there. But like, and right beside the Jeep. Now I don't know. I'm just saying what I think. I'm just going by what I like. What this lady said. She said I parked right beside him. So that means also, she said when she looked up in the window, she saw Xana Kernodle looking out her bedroom window. And then when she pulled in, like, she said she could see her, like, she like disappeared, kind of like she was coming down to get the food. So if she saw her, Bryan Kohberger definitely saw her. And if Bryan Kohberger saw her, then he definitely knew there were people awake in that house. So he allegedly would know that he would have to kill more than two people, one person. You know what I mean? Like he would at least be like, okay, well, there's two at least, the target and then Xana. He could have had his car off. Yeah. I'm just like, and then that, and then it still makes me, I'm still on that front door. I'll be on that front door till like they tell me otherwise. I've looked up everywhere. I've Googled, I chat GPT. I've done Google AI, and there is nowhere that I can find about that backsliding door being open. The news conference doesn't say that. It says a door was open. Somebody, if anyone knows where they can find that information, and maybe I'm blind. I am blind, in one eye. So if you're like, I need to know exactly where it is, let your girl know. Because I'm going nuts over here. Yeah. Yeah, that's what I'm saying. Like, but if she saw Xana, then he definitely would have saw her. And if she pulled next to him, it would make me believe, like, that she was parking in the driveway. I don't know. I've always assumed that he went to that back parking lot, but I don't know. Something always kind of felt off about that too. So we'll see. We're going to see. I don't think we'll be getting any continuances today. So I think we'll be going to court soon. Well, there was plenty of room for her to park. Let me see. Gosh, Google is the best when it needs to be. Let's see. Okay, here's an overhead picture. But that car's out of the driveway, so that's not a very good picture. Right here. So, or wait, is this one better? This one's better. There's plenty of room to park. So, ugh. Now I'm like even more confused, Was he parked there? But at night you would think you would see all in those windows, like a light, like, you know what I mean? Like the headlights coming into the driveway. But maybe he took that, I don't know, maybe he took that as an opportunity to enter through that way because he assumed maybe she didn't lock the door behind her when she got her food. I don't know. We're going to all find out together. It's going to be an exciting trial. I'm ready for opening statements. I am so ready for opening statements. Oh, also, our buddy still has yet to come back to the platform there, or whatever his name is. William, Bill. And everybody seems to think, which is hilarious to me, that they got to him. And I'm like, no, they didn't get to him. And they also wouldn't remove his videos. Yeah, the fatty lover. They wouldn't remove. He did nothing other than he doxed himself, but that's himself. Like he did that to himself. So I don't think that's even against terms of service. So he didn't do anything that was against terms of service in those videos. So they wouldn't have taken his. And if they did, they would have taken on his whole channel, right? So these people are in his comment section, like, oh my gosh, he had to delete his videos, and they're in my comment section too, because they got to him, and I'm like, you guys believe anything. Not you guys, but you know what I mean. The people that will. If I just said, My name is Tanya, and I know Bryan Kohberger, and you don't. And I don't think he would do this. And I'm an Aries, and I was in the military. Would y'all believe me? I mean, I would hope not. Oh, CJK, there was the newest member was unlocked. There's a guy named William that came out that said that he knows Bryan Kohberger, but he said he didn't say how he knew him. He lives 2.5 hours away. It was weird. It was weird. Very weird. Now, these guys are going to take forever and a day to probably come up on here. Let me share this with you guys. But maybe not. Maybe Judge Hippler will be like, let's do this thing, because I'm ready. I'm ready to do it. But yeah, I didn't get a chance to watch all of that thing from News Nation, but it looked pretty interesting. Oh, it looks like Brian Enton is there. So maybe we'll go over to Twitter. See if he has anything to say while we're waiting. Or X. I swear I'll get it one of these days. Let's see. I was going to go down to the pool today and stream from the pool because I was like, well, that would be nice, right? And then I went down there. I got all ready, went down there, and it was closed. I was like, are you kidding? Oh, favorably, CJK. The only thing that he said at all about him was his name was Bryan Kohberger, and that he knew him and that he would never do this. He's not capable of this. That's it. It's a couple videos back that I did, and because he deleted his videos, but we have them. And then the second video, he doxed himself. He was like, my address is blah, blah, blah. Like before I could even like say, what is this guy doing? There it was. And then like 8 hours later, he deleted all, like he had 2 videos, and then he had a knife throwing short. He was throwing knives. Very insensitive, if you ask me. Extremely insensitive. Boise's one hour ahead of you, baby girl. It's early there, isn't it? Yeah. I'm just reading the chat. Yeah, levitating elephant. That's exactly what it was. And it's like, just give us something. Like, I mean, show me a picture of y'all together, right? Like, if you're such good buds. And he's like 10 years older than Bryan. Like, that just doesn't make sense to me. Right? Like, I mean, or like at least 8 years, I think, if we did the, Yeah, it could have been, Margot. With the way he read it out, I was like, dang. I was like, he just said his address. Because he was like, if anyone wants to come and mess with me, I'm like, no one even knows you, bro. But, in the comment section, we went through the comments, and Harsh was in there, and he's like, I'm going to use your videos tomorrow. And then they were gone. So then he had to like say deleted videos in his title. I went over there because I was like, I want to see if he end up doing a video on it, but I didn't watch it. Yeah, and then he had the sign up of like good creators, trustworthy creators, and they were like, the ones that do the mostest. And then you had fat creators, he said. Not non-factual, nothing like that. It was fat, F-A-T. I was like, man, wow, you're an adult. Oh, Debbie, it was a fake person. Wouldn't be the first time. Yep, that's what I said. I don't believe anything. I don't believe the stuff when it comes out like that. I just don't. I didn't believe the fake Bryan Kohberger call on T-Rev show, and I used to watch him at that time. I was like, this is bullcrap. I think that's when I was like, I'm out. I'm like, I didn't watch him a lot, but like that was just something that was like, what? The fake screams on the audio from Joseph Morris. People, doxing and saying where the victim's boyfriends lived, telling people to go and harass them when they, didn't have anything to do with it. I mean, it's just, I'm sure these people are ready to get past this a little bit. Really? Ooh, we'll lose. I like your new name, Willis. What are you doing? back there getting comfortable. Yeah, fat and short. Yeah. Yeah, he was. I'm like, I take offense to that. I'm in the Excedra, I guess, because there was like I wasn't listed because I'm over here just doing my thing, being myself, being quiet usually. Yeah, Tony, it was just too much over there. I like the call-ins because I thought it was a chance for people to actually call in and voice their opinion, but I don't know, I'm gonna refresh this just in case, but I don't know, it just went to hell in a handbasket, it seemed like, right? I think that he wanted to keep those numbers that he was getting, and that's why he did it, like, and he completely messed up. If he would have came out and he would have been like, I did this and it was shitty, and I understand if you guys don't support me and blah blah blah, like if he did an actual genuine apology, but he just blamed it on other people and then kept trying to keep moving, and we're like, no, everyone was like, no. I know, Squeaky. I think that he just was probably out of the two, we'll give him this. Were you over there too, Cal? Oh my gosh, I bet. I said something one day. It was on a member's post, and it wasn't even mean, but he got up one day and he got on his live at 10 o'clock in the morning, and he had no shirt on. And I'm over here. I think I was up at the same time. We were streaming something, maybe there was a hearing or something. I don't know. But I'm in full get up, right? And I'm like, well, dang, it must be nice to be able to wake up and just get on your live without a shirt on. And I made a joke about it because obviously I cannot do that. I'm a woman, and I mean, I could, but I wouldn't. And he come rolling in like a tumbleweed in my chat that night, and he was like, blah 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 blah. And I was like, do you want a link? I was like, you sound mad. And then he just pieced out. He didn't even I was like, okay. I was like, here's a link. It was supposed to start at 2:30, but they're usually 10 or 15 minutes late. That's why I came on at 2:15, because I was like, anything earlier than that would, probably wouldn't be too much. But yeah, he rolled in here it was just so funny. It was just so funny. I was on, and I'm on camera, you know what I mean? So it's not like you'll get a raw reaction out of me. And at that time, I was just like, oh, would you like to come up and talk about it? They have a verdict again? Oh, wow. I think that they really need to make sure those jurors know what they're doing. Yeah, what they're doing. You know what I mean? Wow. Oh, there we go. Oh, he's smiling, that Joshua guy. He's my new favorite. Him and Bill. Oh, no volume. Okay, now I got it up. Hippler looks like he is just yeah, he don't look very happy. Oh, really quick. I wonder if we'll get a anything about the Dateline episode. I wonder if they'll mention it, the leak or anything, or if they found it.
All right, this is CR 0124316665, State v. Kohberger. On behalf of the state, we have Mr. Thompson and Mr. Horwick. And on behalf of, when the defendant is present with counsel, Ms. Taylor, Ms. Massoth, and Ms. Barlow. This is the time set for, or at least the public portion of today's hearing is set for the motion to continue the trial filed by the defense. So we'll start with that.
Good afternoon, Your Honor. Your Honor, our motion to continue has been filed and is necessary to protect Bryan Kohberger's rights under the United States Constitution and the Constitution of the State of Idaho. Specifically, a continuance is necessary to protect his due process rights, his rights to a fair trial, his rights to effective assistance of counsel, rights to confrontation, Mr. Kohberger's right to present a full defense, and if it should come to it, a fair sentencing hearing, and to be free of cruel and unusual punishment. The record of this case spans 2.5 years, and it shows that this request does not come as a surprise. Looking through the history of this case shows that the defense has met challenges and difficulties along the way, but has been dedicated in meeting all of the deadlines. We have talked about the discovery issues in this courtroom before, and that in large part brings us to need a continuance. 68 terabytes of information is a huge amount of information. There have been 23 requests for additional discovery over the span of 2.5 years and 7 motions to compel. When I say that this doesn't come as a surprise, that this comes from the record, I would direct the court to look back to May of 2023 and June of 2023 and our second motion to compel. Included in that was what was known as Exhibit A from the defense, and that depicted how we were receiving discovery. So this is not a new issue. This is something that's been coming up for a long time. We were receiving discovery, but it was such that you would get a file that would say hundreds of photographs, hundreds of pages of reports, each having to be looked at individually to know what was there and then organized. This case has also faced unique issues, starting with the media coverage of this high-profile case, non-dissemination orders that were addressed in courts, and then the grand jury materials that we had to fight to get access to before we could properly challenge the grand jury indictment. We faced issues with discovery, particularly with the IGG materials. We spent a great deal of time trying to get access to those materials. Those were ultimately what we could get, was ultimately presented in a motion to suppress, and that's preserved should there be a conviction in this case. We faced venue issues in this case, culminating in the change of venue and bringing us to Ada County. At the first hearing in this courtroom, we discussed the discovery issues and not having read everything and being ready with a full investigation in this case. That was apparent through our motions to strike the death penalty, our motions to compel expert disclosures filed in September and December of 2024, and requests for more time to file our motions in limine that was granted in January of 2025. Throughout the course of the motions in limine and then a motion to strike death based on discovery issues in February and March of this year, the record is replete with notice that we are not prepared to go to trial in this case. The discovery is vast and we have not had a chance to review it all.
She hasn't had a chance to review it
deadlines
all.
for experts shows our dedication to comply with court orders. It does not depict effective counsel ready to go to trial on this case. We would submit that it's the court's responsibility to assess this motion to continue with heightened due process that's required in death penalty cases. The death penalty case is different. That comes from Ford versus Wainwright at 477 U.S. 399 at 411. The court must be sensitive to safeguard every avenue of due process. The Idaho Supreme Court said the qualitative difference between death and other penalties calls for a greater degree of reliability when death is imposed. And that comes from State versus Creech, 105 Idaho, 362 at 383. Looking at all of the constitutional rights Mr. Kohberger has, effective assistance of counsel really becomes the crux of how all of these other rights are covered for Mr. Kohberger. An effective assistance of counsel applies both to the merits phase and the penalty phase of a death penalty case. The courts are guided and counsel is guided by the American Bar Association guidelines on capital cases. Wiggins versus Smith, 539 U.S. 510 at 524 said the ABA guidelines are guides to determine what is reasonable. And that's talking about reasonable performance by defense counsel in a capital case. The Ninth Circuit in Andrews versus Davis at 944 F3D 1092 at 1109 relies on the ABA guidelines as the proper measure to test an attorney's investigation. In Idaho, our public defender statutes reference the ABA guidelines as applying to indigent defense. These apply to the full investigation of the merits phase and require us to raise all legal claims. They require us to perform a background on all witnesses that might be called, especially those being called by the state. That means that we have to review all discovery to be able to present a full defense for Mr. Kohberger. We cannot present what we are not aware of. I would note for the court that discovery has been ongoing. I received discovery just this week. It is discovery that I have not reviewed yet. Considering what's required at a penalty phase in a capital case, we're required to perform in a way that the jury can carry out their function of individualized sentencing. That means that Mr. Kohberger's background has to be known and investigated and ready to present to the jurors. Evidence of his character has to be known and ready to present to the jurors, and his circumstances have to be known and ready to present to the jurors. That's addressed in the Woodson case and in the Lockett case. The jury must have the opportunity to consider all evidence.
Seriously,
that may
all
weigh
jokes
against
aside,
the
who's the
defendant, and
lady
that
with the
means
tank top in the
from
courthouse?
his life history. It
I'm
is the
done.
duty of the defense to find and investigate all mitigating information. We do have several experts that would be ready for the mitigation portion of the case, should the case reach that phase. And they rely on understanding family history and Mr. Kohberger's own history. They can only understand what they've been presented. And the investigation to fully evaluate needs to be thorough. That means that records have to be collected. That
Prosecution
means
could
that
do it.
interviews, collateral interviews have to be done, and those have not all been completed. And it's not because of a lack of diligence in this case. Further, when things that are noted as red flags arise, those things must be investigated. Red flags aren't fanciful ideas of what else could we do in this case. They're real things that come up in the course of the investigation, and whether or not they're important to mitigation and presentation for a jury's consideration requires time to investigate and collect records. Documentation is very important. The court's aware that red flags have come up and they require further investigation. Those are issues that may mean a lot to the experts that would be ready to testify, but they can't be presented until there's a full investigation. They are things that might change the course of the evaluation or might require us to have an additional expert to help explain certain circumstances. And that's important for the individualized sentencing that's required by the Constitution. Your Honor, there have been numerous challenges with gathering records and interviewing collateral witnesses. I know the court is aware of some of those particular issues. I'm not going to highlight them now, but it's imperative that we be able to collect records and conduct interviews from other family members besides just Mr. Kohberger and his parents. And it's also imperative that his history be complete with educational records, medical records,
You haven't got
and those
these?
things are still being done to this day. The other reason that a continuance is appropriate in this case is based on the media coverage,
What has she
the
done?
Dateline issue that has been talked about in this courtroom before, and what's yet to come. The Dateline episode
Oh, you ain't telling me nothing.
wasn't just a one-time deal back in May. That continues to be talked about. Everything that happens in this case continues to be talked about, and this court has a duty, a responsibility to make sure that Mr. Kohberger receives a fair trial. That comes from Shepard versus Maxwell, 384 U.S. 333. And a continuance may be the way that the court can best protect Mr. Kohberger. That comes from Patton versus Yount, 467 U.S. 1025. In addition to what is going on with what happened with the Dateline episode, that's not all. There's a book set to be released just a few weeks from now to be followed by a docuseries on Amazon Prime. There's a claim that there's inside sources that provide information in this case. At the very least, the moment we start attempting to select a jury in this case, those things are going to be on everybody's TV, everybody's social media feed, and some of the very witnesses that will be expected to testify will be taking part in the docuseries at least, and maybe noted in the book. That is in and of itself an exceptional reason for us to have a continuance to let those things play out for a while. I would also note, Your Honor, that jury selection is going to be particularly challenged and will need a great deal of time based on what's happened in the media and continues to happen. Your Honor, our request is for a continuance in this matter to allow us to be effective and perform our constitutional duty for Mr. Kohberger, to protect his constitutional rights, to make sure that we have fully investigated all mitigating circumstances so the jury, if it comes to it, can perform their individualized sentencing, judgment, and function, and to allow some space between what's recently happened in the media. Thank you.
Thank goodness. Okay, get up here, Josh. Like your suit. Now that's how you dress for court. I'm gonna give them a style. I'm gonna give them a style too, or like on how to go to court, present yourself in court. Go ahead.
Thank you, Your Honor. I will, I think, address Ms. Taylor's argument sort of in the reverse order in which she raised the issues that she raised. I want to begin, though, by bringing us and the court back to what the standard is for this motion to continue as opposed to what might happen after a conviction with respect to ineffective assistance of counsel. Right now, the standard is whether denying a continuance would violate the defendant's rights by causing unfair prejudice. And that is an objective standard that the court has, and the court has discretion on all motions to continue, including a motion to continue in a case such as this that involves the death penalty. What the defendant and counsel are asking the court to do is delay this trial because of their subjective, prospective beliefs about how an ineffective assistance of counsel evaluation would happen by an appeals court if there is a conviction. What this court should do is use its discretion and look at the objective record. The record supports denying the motion based on what the defense has been doing, continues to do, and will continue to do through the mitigation phase until the penalty phase, including presenting mitigation evidence that the jury will ultimately decide about if there is a conviction. The lens that the court should look at is well stated, through which the court should look at this motion is well stated in some Idaho case law and others. And if I can turn on the Elmo, do I need to hit this button, Your Honor?
And Clark needs to switch it over.
Okay,
What's the
thank you.
Elmo? Oh, look at that little projector. They don't make them like they used to.
So these are cases that we cited in our brief, and I wanted to start my discussion with them. I'll read the top case, which is an Idaho Supreme Court case, evaluating whether counsel was effective in a death penalty case. Counsel was not required to investigate defendant's entire life in order to objectively and reasonably present mitigation evidence. And then I like the way that the Seventh Circuit sort of rephrased the same principle by saying, I won't read the entire quote, Your Honor, but a scorch the earth strategy is not required. We're in a standard of reasonableness. And the record that is before the court, and I'll acknowledge we have not seen what specifics, if any, the defense has put forward in its ex parte filing.
It's kind of hard for you, I recognize.
It does, but we have not seen specifics. I did not hear any specifics from counsel just now about these witnesses need to be contacted, these records need to be obtained. And then the court, I think, mentioned at prior hearing we had when this was motion to continue was first raised, that the court would be looking at what admissible evidence the defense needs to obtain and what strategies would actually be used to fruitfully obtain that evidence. And we don't have anything specific that we can respond to about that. So I'm at a bit of a disadvantage, Your Honor, but I think the record that we do have shows that the court can use its discretion to deny this motion to continue. What we did in our response brief, Your Honor, was to cite the fact that the defense has identified 55 defense witnesses for mitigation, and I think one was recently added, so we're up to 56, 132 exhibits to use at the mitigation phase. And with respect to the ABA standards,
She
we're
did
not
all
saying
that
the
for the
court should
mitigation.
completely ignore them, but what we are saying is that the court should look at them for what they are, which is a retrospective tool for appellate courts to look at the performance of counsel after a conviction, not some checklist that needs to be religiously adhered to in order to actually get to trial. Even if the court were to rely on them heavily, though, the charts that we put together show that for each of the ABA guidelines categories that the defense has raised, we have seen evidence in the record that shows that they have witnesses to talk about those issues and they have discovery on those issues themselves. Now, defense has called that superficial, but we would ask the court to look at the tables and look at the witnesses that we've been able to identify for each category and also the discovery in the record. So, Your Honor, again, we think that given the legal standards here on a motion to continue, given the court's discretion, given that we are in a world where the court needs to satisfy itself that defense has done a reasonable job to prepare for trial, excuse me, to prepare for trial, there is no basis for a motion to continue. Now, let me turn to some of the specific arguments, and I can take this down, Your Honor, that Ms. Taylor raised. With respect to the media coverage, we acknowledge, as the court has, that will pose challenges for jury selection. The issue, though, is not whether there is a lot of publicity. We know there's going to be a lot of publicity regardless of when this trial happens. As Ms. Taylor said, people will continue to talk about this case. The issue is whether the court, using the procedures it has established, or maybe even modifying them as the court wants to, can seat a panel of impartial jurors. The Supreme Court of Idaho has found that despite widespread publicity, even on the day of jury selection, that is possible. That is possible in this case, despite the challenges. The other thing I would mention with respect to the publicity is that it puts us at the whim of the media. Every time there's a breaking story, every time there's a new book or a new documentary, are we going to continue the trial indefinitely? And that seems to be the danger in what the defense is asking for. We call it a perpetual continuance, and we haven't seen a proposal about when this trial could take place if there's a continuance. What seems to be the strategy here is just to delay. And that leads me to, I think, the other point that Ms. Taylor raised, which was to say that this shouldn't be a surprise. It is a surprise to us that a motion to continue was made so late in the game, after, by the way, the trial date was used to oppose an extension that we filed for with respect to our mental health expert. At that point, the defense said we can't possibly go down this road or give the government the state what it wants because of the trial date. Once that issue is resolved, then we get a motion to continue. So I think what we have seen from the defense is that they tried to use the mass amount of discovery to remove the death penalty from the table. When that failed, now we have a motion to continue. So I do think timing is relevant here. Again, and it's not just that the defense waited so long, it's that we now have a very substantial record on which the court can deny this motion based on everything that's been put in front of the state and the court. In terms of the mitigation investigation, Your Honor, we believed but did not have confirmation that the defense had a mitigation specialist until the reply brief on this motion alluded to an affidavit that mitigation specialist submitted. So I don't know what that says. I don't know what the mitigation specialist has said, but the fact that there is a mitigation specialist, apart from the 3 attorneys and 2 investigators that are part of the defense team, That person has one role, as I understand it, which is to prepare for the penalty phase if we get there. And that person, that specialist, has still time to continue doing whatever work they told the court they need to do. Your Honor, again, I would try to get back to the record and ask the court to look at the objective record when evaluating this motion. 55 mitigation witnesses, over 130 exhibits, a very robust team on the defense side, which includes their retained experts. Ms. Taylor, and in the briefing, really honed in on this idea of a social life history for the defendant. I don't know if the court has read the expert reports of the defendant's forensic psychiatrist and then the licensed psychologist. I won't discuss the details in open court, but our position is that both of those specialists, well-trained, very experienced specialists, conducted significant, fulsome life history investigations. They weren't just looking at bare records. They were talking to people from the defendant's past, from his present, his family, and developed parallel life histories. And in their reports, as I read them, no red flags that needed further investigation were noted. Nothing about those reports appeared to be incomplete. And the experts didn't say, we are unable to reach the conclusions we need to reach for lack of investigation. So I think that is sort of proof in the pudding. We have a life history for the defendant. The defense has amassed significant materials. And I thought we were going to be solely talking about the mitigation case that still needs to be developed. That is not a basis for a continuance. And to the extent there are ongoing discovery from the state that Ms. Taylor alluded to, I can represent that most of what was just turned over was our investigators speaking with witnesses that the defense has disclosed. So that's the nature of that discovery, is us responding to discovery from the defense. And that will continue, of course, to occur as we lead up to trial and witnesses make statements that we need to disclose to the defense. So with that, Your Honor, I would again rest on the case law holding that a scorched the earth investigation is not what's required. And on the record before the court should exercise its discretion to deny the motion. If the court has any questions, I'm happy to answer those. Otherwise, we would submit on the record before the court.
Thank you.
Thank you.
Any reply?
Yes, thank you. I would start with noting that if the new discovery is the state's contact of witnesses we've listed, the state knows that there are mitigation witnesses that we've listed because we had to disclose them, but they are people that have refused to speak with us. That presents a challenge in the case. A lot of the witnesses that refuse to speak with us have to do with records, medical records of Bryan Kohberger, past treatment records of Bryan Kohberger. Those are important things that the gravity of what they have to say can't be known to our experts until we have the opportunity to fully understand those things. And we continue to work on access to witnesses and access to additional information.
What witnesses?
Your Honor, I want to touch on just a couple of points. One, when the court considers a continuance and considers whether Bryan Kohberger's rights are violated, his right to a fair trial, his right to confront witnesses and evidence against him, his right to present a full defense, and his right to effective assistance of counsel are implicated and laid out in our motion to continue. The ABA guidelines require us to do a full investigation. It's not going scorched earth to understand Bryan Kohberger's full life history. These are things that are required. And we've done everything that we can. We have had a mitigation expert on the case. This is 2.5 years into a case, and the average for capital cases is 3.5 years
In federal court,
in federal court.
which moves at a snail's pace in its best day in regular cases.
I'm not a practitioner in federal court, so I don't have any basis to talk to the court about that. But what I can tell you is that a capital case where we have a client and we need to investigate both the merits phase and a penalty phase at the same time takes time. In any case, it takes time to do that. In this case, with the high profile nature and having people decline to talk to us presents a whole set of challenges that we have to find a way to work through. As the court knows, a lot of mitigation information is very sensitive information. It takes some time to be able to get people to talk about things. Realities exist too. Not all of the family members are in the same place. So there's travel
Well, they
that's
should be.
required. All of those things take time to do in a case like this. 2.5 years is excessively fast to put all of that together. There was no delay in having a mitigation expert on board. There was no delay in getting investigators to work on the case. And as soon as issues became apparent, Mr. Kohberger's team did not delay in getting experts to help us understand specific areas of the case. Looking over the entire record, the court can see that the defense team has been diligent about discovery, about motion practice, about litigating issues in the case. There just still is a lot left to do. There is still a lot left that is not known. And Mr. Kohberger has a right to go to trial with prepared counsel that have conducted a full investigation in both phases of the case. When you have a certain amount of information and there's this other stuff that's out there, that's a red flag, that's real, that you need to investigate, your experts can only do what's here, what's been investigated, what's been produced for them to assess. This whole other area, that land between the red flags and the investigation, that's an unknown area. That's where there's ineffective assistance of counsel. That's where there's not a fair trial. That's where there's not an individualized sentencing proceeding. And it's that area that requires a continuance in this case.
How much of that 61 terabytes you've been through? That's what my question would be. Oh, Catherine. He's probably writing down some cuss words right now.
All right, I'll take the
Right,
matter under
Tom?
advisement
Oh.
and get an opinion out in short order.
You kidding me?
In the meantime, I fully encourage everyone to continue as if the trial is going to take place when it is scheduled for. Again,
Hippler.
I reserve the right to write the decision that I come to, but as of now, I would tell you that it's likely you're going to trial on the date indicated.
Well, that means we're going to trial.
All right. Is there any other matters that we need to take up in the public session before we break to go to the private session?
This is the fastest session we've ever had.
Nothing further in the public session.
Nothing further. Look at Kohberger.
I don't believe so.
All right. We'll take a 10-minute break while the bailiffs clear the courtroom and we set up for the private session.
All rise, please.
Oh, wow. Okie dokie. Wow. Well, if you're a Karen Reed supporter and you or you think Bryan Kohberger may be guilty, that's a win-win for you guys today. Within 5 minutes. Wow. So pretty much, ALR, he said he's going to get an answer out to us in short form, meaning to me, that's not going to be a long document. It's going to be like a couple, few pages. He's going to cite some case law. He's going to say, you guys have had this much time to prepare for trial. You're telling me, I guess there's 10 more terabytes they added on. If you guys didn't hear her say that, I swear it was 51 terabytes whenever they first got the discovery or whatever. And she just said in this session, 61 or 63 terabytes they have to go through. So either she like, made a little mistakey there and just like her wording, or they gave her an extra or extra like 10 terabytes or more. Well, shoot. What's Jay Logston doing over there? What's he doing? Like just putting up her feet or put up his feet, I mean. Well, her feet too. I don't know. That guy was not, that guy was something else, but Bryan Kohberger didn't really seem to like Jay Logston. So I don't know. Tell her no, yeah. So pretty much, yeah, he's gonna, yeah, we already watched it. Felicia just went off. He said that she came and, she said her reasoning. She said she's not ready. She's not ready to go to trial. She said something about 60 some terabytes, which it used to be like 50 some. So it's like, I'm just wondering when she got him what it is. It could easily be when they went back in to the house and they redid some stuff, like the officers, they went back in and they like remeasured. You remember that? They took all the plywood off the windows and they were measuring, and like one of the guys was out the window and stuff measuring. So, but yeah, she'll never be ready. If it's her way, I think that's all she can do is just keep Bryan where he is. He might like it. He might like to be segregated from other people. He might be the most introverted person in the world. He might be able to go in jail and sleep. I've known people to be able to do that. They go to jail and they just go sleep for like a week and then they come out. I wouldn't be able to do it. I wouldn't be able to do it for this long. I would be like, I'm ready to go to trial, especially if I'm innocent. Because I mean, you have to put your faith in the court system as Bryan Kohberger, right? I mean, what are they going to do? What are they doing? Like, they're going to stall until what? They can't stall anymore. And he goes on trial anyway. Like, and the victims do have rights. So they're taking a 10-minute break and then they're coming back for the closed portioning of the hearing. So yeah, it's over now. Like the hearing part that that was open to us was just the continuance. They're taking a 10-minute break to clear the courtroom of anybody that shouldn't be in there, and they're having a closed hearing. She says that she is an alternate perpetrator theory, but that's all she said last hearing. And she's supposed to have evidence at the end of May. I think May 25th was her deadline for the evidence for the alternate perpetrator. And so they're supposed to be hearing that today. And then I don't know if he may give us a ruling on that, or it may be sealed. If it's going in her favor, even if it's not though, he could seal it. I'm saying that they're not going to just throw a name out there, right? Like if she's like the alternate perpetrator, I say it's, Tom. Like she can't just like throw out a random name. You know what I mean? She has to have the evidence to back it up. So sorry, Tom, I put that on you. Yeah, and like, well, she wants to be included in all of it. And I'll say, although I give her crap for it, I'm the same way when it comes to like, I want to see everything that like, I'm one of those people, like I like to see it for myself. It's better for like, I don't know. I feel like if I was Ann Taylor, I would want to see everything, but she's had so long to see at least some of it. And she came in today saying she hasn't seen any of it really, but she did stuff for the mitigation phase. That's after trial. Like, why are you over here when we're all back here? We haven't even went to trial yet. So it's like, get your stuff ready. So yeah. But thank you guys for being here with me today. That was like an hour long live. Look at that. I may come back on tonight. I'm not sure. If I do, I'll make a thumbnail and everything so you guys will know. Maybe I will, since we didn't do that long of a live today. I have a bunch of stuff, I just need to go through and just show you guys. Like, I have 1, 2, 3, 4, 5, 6, 7. Okay. So 7 pages are like minimized, but on each page, if you pull it up, it has like 20 freaking tabs on them. I don't know why I'm keeping all this stuff. Like, I don't know why I just don't put it in a folder. Because I have an Idaho folder, but I always feel like when I put it in that damn Idaho folder, I can't find it. Yeah, yeah, she was found like right before this happened. It was all at the same time. I don't even know why they charged her with the OVI to be, I feel really bad for John's family. Because in my opinion, I haven't seen her stick up for them people once, not once. And if that was your boo thing, that was your man, that was your everything. Like if that was Vincent's mom, I told him we talked about this last night. If Vincent's mother had to go to the courthouse because Vincent was dead and they were blaming me, there is no way on God's green earth that I would let a gang of freaking people, and that's what it was, the first trial especially, go after that person and yell at them and boo them as they're walking into the courthouse. And like, that's just disgusting behavior. Like, I mean, it's just disgusting behavior. Man, that's just not right. I mean, John O'Keefe's family did not do anything but lose their son, right? And like, if I was her, I would have said something. That's just me. So. Yeah, but it's like, I don't know. I wouldn't even charge her with the DUI. That's like, I went to court one time and they charged me with clearance. They were like, we're going to charge you with like speeding or something and like something else. And then they were like, and clearance. And me and my lawyer at the same time made a noise. I was like, what? And he was like, shit. And like, he was like, he's a cusser. My lawyer's a cusser. But it was just like, it was like, what? It was like just like her, she is not guilty of murder, but they're going to charge her with the DUI. Just let her go at this point. Just let her go. Let her go and live her life. And, yeah. But I don't know why people are, I mean, I know that she is free because she doesn't have to go to court anymore, but she's been free. She wasn't in jail. So I don't know why people keep saying that. But yeah, so congratulations, Karen Reed. Sorry about your luck, Ann Taylor. I don't think it's going to go in your favor. He said, you guys might as well just keep on trucking forward like we are going to trial August 11th. So, I was trying to see if there's anything on. Oh, that's sad. Okay. I swear, if I see another Bryan Kohberger freaking AI picture, who was doing this? Is this the same lady that was doing it before? Somebody had him knitting in the woods. I was like, oh, right. Look at this. Look at this. Oh my. I'm not going to show you guys this. This is insanity. Somebody get this woman off the internet. Oh, you guys can't see it. Look at this. Look at him. He's got a raccoon. He's got a bird on his shoulder. Like he's just like he's freaking Snow White. And he's writing in his little book. Speaking of which, let me see if I can find it. Oh man, where would that be? Right here. Oh my gosh, how did I do that? 7 tabs and like I swear I've got or 7 folders and like a million tabs. Okay. You tell me who this looks like. So they were saying there's a rumor, and I should have the article somewhere. I remember seeing it that Bryan Kohberger allegedly, they said, they thought they saw him in the student center prior to the homicides. Look at this guy. You tell me if that is not Bryan Kohberger's freaking doppelganger or that's him. You want me to zoom in? I think I could zoom in for you guys. Let me see. If I turn my camera off, I usually can. It's weird how I can do that. Now I got to find it. Which one was it? Of course, like the first time I got it, I couldn't. I'm trying to. It looks just like them. I was like, when I saw this the first time, I like really was freaking out. I think I showed it to you guys a while back. Trying to find where I just had the dang picture because I have it in another tab, so I might not be able to zoom in. because I can't even find where the picture went. Yeah, I can't find where we were. Let me see. How do you do this? Wait, right here. Okay. Let me see if I can like zoom in a little bit more. I don't know if I can because it has like that little thing zoomed in already, or like the magnifying glass. Oh, I can. I don't know. It just looks like him to me. It looks very similar. I don't know who his two buddies are, but it just looks like him. It's probably not him, but I mean, it's just funny, you know? Hey, Doodlebug. But it does remind me of him, doesn't it? It looks like his twin. I mean, this looks more like him than the guy in the blue coat at the vigil, you know? And they said that he was in the student center too. So I just thought that was pretty funny. Just going to readjust myself here, but I just thought that was pretty funny when I saw that. Cause I was like, oh, that looks like him. Like a side profile with his head down. I should have looked at the eyebrows. Yeah, the nose. That's what it is. Like the nose is what got me like that. Like, I don't know if it's like boxing or what. Or maybe he has like a little bit of like Italian genes in him. Yeah, hanging with raccoons. He enjoys that activity. It could be his little brother, couldn't it? Man. It's a custody spot. That's so funny, Samantha. Did he have a good life? Hopefully he did. I thought about asking if he wanted, well, we don't have a lot of hearings anymore, but it would be kind of cool to stream with somebody. Like the hearings, it would have been like, because, you know, like, I don't know, sometimes they can get a little boring back and when we were hearing them, you know, we first started listening into some of them, like, I don't know, the beginning was like exciting. I'm not gonna say that. Like some of the hearings were a little dull, you know, we're not going to lie about that. But Tom, that's funny. He enjoys that activity. That's funny. That's so funny. Well, oh, actually, let me check the poll. It says 70 no. Do you think it says, do you think Bryan will get a continuance? 14% yes, 70% no, 16% not sure. It'll probably say something different when it pops up, but sometimes it does. But I'm gonna jump off here. Maybe I might be back on this evening. Because like I said, I have a bunch of tabs open. We can surely find something to talk about. And they did put out new pictures of Travis Decker. They are terrible, in my opinion. The pictures are. I think I actually have them on my X because if you're not following me over on X and you have Twitter or X and you want to, make sure you do because I do retweet a lot of stuff over there because it's just a little bit easier than making a whole community post. If it's just something quick, especially like missing persons flyers. If I see a missing persons flyer, I'll always try to retweet it. But this is picture. I mean, this looks spooky to me. Like this looks like the old filter or something was added to his face. I don't know how they did this composite, but it's a little weird to me. But this is what he could look like. I mean, he could even have taken the gauges out of his ears. So, because those are gauges in his ears. They're not earrings. They're like, you know what I mean? Like the holes, like they're real small though. Like his aren't big, very big. But he's 5'8", 190, black hair, brown eyes, last seen wearing tan or green t-shirt and dark shorts. And it's just Chelan County Sheriff. And their telephone number, do they have one? Yeah, 509-667-6851. Johnny Cochran. Man, I'm gonna get sued. Joyce, I don't know who does those. I actually you can go to Grok if you go on X and you can say, you know, make me a picture of Bryan Kohberger knitting a blanket in the woods. And it'll literally give you that. We should do chat or like Chat GPT or something on the channel one night about Bryan Kohberger. Just see what it comes up with. It'd be kind of funny. Whenever we need, like, you know, one of those days where we just need it to not be so serious. So I will keep my eye out on the documents if they're dropped today, for today's hearing. They might be dropped today sometime. And then I'll probably come back on later. Make sure you hit the like button if you guys don't mind. But I mean, you guys have been great about that. So I appreciate that so much. And yeah, I'll be back on later this evening. Hey, Kathy, we're getting off now, but make sure you go back and check out the video. They didn't give us a definite answer, but they did say, hey, just act like we're moving forward to trial. I wish that we could do like a split screen where like half of it is like my reaction and half of it would be like somebody else's reaction. That's more on like the not guilty side of Bryan, like when these proceedings are going on, because I want to see how they're like taking the information and how they're perceiving it, because I would just like to know that. But yep, I'll be back on probably this evening. If I don't, I'll like put a community post or something up for you guys. But thank you guys for being here with me today. I appreciate it, and I'll see you guys later. Bye, guys.
Just like the street lights lit this town, like a fire in a blaze, gotta burn it down. Can't be afraid to leave this out.